This presentation will set out the protection and prevention options available in Australia for cybersquatting. But first, a definition. Cybersquatting is an act by an individual or corporation of registering a domain name with the intention of squatting on that domain name in bad faith. The key factor here is bad faith. General indications that a registration is in bad faith have been described by the World Intellectual Property Organization as an intention to buy, sell, rent, or transfer the registered domain name to a business or trademark owner for profit. Other reasons may be a competitor attempting to disrupt business or creating the domain name in an attempt to confuse users into a competitor's website. Before protections can be fully explained, a brief overview of the domain name system and trademarks will be provided. The intention of the domain name system is not to provide property rights to the owners of a domain name. Rather, it is to allow users ease of access to the wonders of the internet. Registration of domain names in Australia is provided by the Australian Domain Administration, or AUDA, on a first-come, first-served basis. There can only be one exact domain name in existence. Meanwhile, a trademark is a mark that distinguishes your company's product from another. A domain name is a digital mark that identifies and distinguishes your organization from another, usually in connection with the sale of goods. Registration of the trademark in Australia can provide protections to the owners of a domain name. These protections include excluding all others from using the mark and obtain damages if the mark is used to the detriment of the business or dilution of the mark. The court in CSR v Resource Capital Australia noted that registration of a domain name that a general user would assume to be the same as a registered trademark holder may be deceptively similar or substantially identical and so breach the trademark. In comparison, the court in Solarheart Industries v Solar Shop noted that registration of a domain name does not automatically infringe trademark. This means that trademark protection will not automatically apply to a cybersquatter if the cybersquatter wishes to deal with the owner of trademark and content of the website does not deal in goods related to the trademark holder's course of business. Remedies to prevent cybersquatting include injunction to prevent further use of the domain name or its variations and, as in the case of CSR, handing over the domain name. Another prevention comes in the form of Australian domain name registration. Australian businesses wishing to obtain a .com.au or .net.au domain name are required to provide information stating that they are a registered Australian company and are currently the applicant of a trademark over that name. This is a protection because it only allows for genuine Australian businesses to obtain domain name, which mitigates cybersquatting. Unfortunately, documents can be falsified to obtain domain names, or the applicant can just apply for a .com or .biz address, as these do not carry as stricter policies. Finally, there is a protection in the form of mediation. The WIPO rules provide for domain name registers, such as AUDA, to provide dispute resolution services. AUDA Dispute Resolution Service, or AUDRP, allows for domain name disputes, including cybersquatting, to be mediated out of court. This reduces recourse costs to the parties, but there is still a contribution required of about $2,000, which may be detrimental to small businesses. Outcomes can include applicants obtaining a domain name that was registered in bad faith. In conclusion, cybersquatting is bad faith registration of a domain name. Domain names can be trademarked. Trademarks can provide protection and remedy. AUDA provides registration processes, providing protection for Australian domain names. AUDA also provides dispute resolution, which can provide protection to affected businesses.